Hello friends, I welcome you all at Swayam platform. I, Dr. Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University. We are discussing the fourth week of the course entitled as Hindu Personal Law including Marriage and Succession. And we are focusing in this week about the Hindu Marriage Law Part 2. And today I am going to focus on the cruelty as a ground of divorce. Friends, in the last class we started our discussion about the divorce and I explained you the fundamental concept of the divorce. I also discussed with you the history of divorce under the Shastric Hindu law. I also discussed the evolution of law on divorce under the Hindu Marriage Act. I also focus on the amendment in the year 1964, 76 and 2019. 3 times happened in relation to the divorce. Friends, I also discussed with you about the different theory related with the divorce, where we discussed the undissolvable union, we discussed the will theory, which is only applicable in the Muhammadan law, not in Hindu law. We also discussed the frustration theory, mutual consent theory, irritable breakdown theory. And after concluding the theory part, we also discussed the entire statutory scheme on divorce, where we categorize the divorce in two broad categories: statutory divorce and customary divorce, which is mentioned in section 29 of Hindu Marriage Act. Friends, we also discuss about the statutory divorce may be categorized in three broad theories: fault theories, frustration theories and mutual consent theory. The fault theory includes section 13 subclass 1 subclass 2. Friends, fault theory further classified the grounds available for the husband and wife both and ground exclusively available to the wife. Friends, we also discussed the frustration theory because of the judicial separation and restriction of conjugal rights. Though there is no cohabitation between the husband and wife, then marriage is not exist in practical sense, it should be dissolved, and therefore we have a provisions under section 13 under bracket 1 capital A. Friends, I also discussed the mutual consent theory about that last class, and after that in the last class we also focus on the ground of adultery and what is the meaning of adultery and what do you mean by adultery under the criminal law and Hindu law. Friends, the point to be noted that after Joseph's sign, adultery is only a matrimonial offense, and when a person during the subsistence of a marriage have a sexual relationship with other, it is amount to adultery, and adultery is a ground of divorce because it is considered a matrimonial offense. Friends, after discussing the adultery as a ground of divorce, now I want to focus on the another important topic of the divorce, that is the cruelty. Friends, before starting the discussion, I want to focus on the learning objective of the today's class. The learning objective of today's class includes the cruelty as a ground of divorce under Hindu law, meaning and the concept of cruelty under the Hindu law vis-a-vis criminal law, the modified ground of cruelty after the 1976 amendment, kind of cruelty with specific case laws, the guideline for the courts while deciding the cases on the ground of cruelty. So these are the learning objectives of the today's class, and by this class we are able to understand different dimensions related with the cruelty as a ground of divorce. Friends, first I want to focus on the statutory provisions of the Hindu Marriage Act. Cruelty is a ground which is defined under section 13 subclass 1 subclass 1A. Friends, the provision of section 13 subclass 1 provides that any marriage solemnized whether before or after the commencement of this act may on the petition presented by either the husband or the wife be dissolved by a decree of divorce on the ground that the other party, and the provision is, has after the solemnization of marriage treated the petitioner with cruelty. after the solemnization of marriage, treated the petitioner with cruelty. Therefore, cruelty is the ground of divorce. Friends, the cruelty is recognized as a ground of divorce by the amendment in the year 1976. Friends, prior to the amendment in the year 1976, originally cruelty was one of the grounds available for the judicial separation only. Originally it was not meant for the divorce. Friends, because when first time the reformation started in Hindu law, the legislature not to create controversies, and therefore they confined the ground of divorce. Therefore, cruelty that time was not recognized as a ground of divorce. Friends, the cruelty was not defined in the act, but under section 10, originally under section 10 of Hindu Marriage Act 1955, which dealt with judicial separation, the word cruelty was used in a restrictive sense, friends. Friends, as per the original definition, the cruelty for obtaining the judicial separation under section 10(1)(b). 10(1)(b) means before the amendment of 1976. Because friends, now the ground of divorce is substantially changed in the year 1976. But prior to 1976 amendment, cruelty was considered the ground of judicial separation and provided under section 10 of Hindu Marriage Act. So therefore, I want to discuss with you that time section 10(1)(b), in order to explain the cruelty. That time the provision has treated the petitioner with such cruelty as to cause a reasonable apprehension in the mind of the petitioner that it will be harmful or injurious for the petitioner to live with other party. So this was definition which was accepted before the 1976 amendment. Has treated the petitioner with such cruelty as to cause reasonable apprehension in the mind of petitioner that it will be harmful or injurious for the petitioner to live with other party. Friends, now I want to focus on the meaning and the concept of the cruelty. Friends, section 13 subclass 1(a) used a phrase after the solemnization of marriage, treated the petitioner with cruelty. So now after 1976, cruelty simply has been made a ground of divorce without putting any statutory rider. The cruelty was defined in a case of Russell versus Russell in the year 1879 by House of Lords, friends. And House of Lords defined that conduct of such a character as to have caused danger to life, limb or health, bodily or mental, or as to give rise to a reasonable apprehension of such danger. Friends, D. Tolstoy in a book, The Law and Practices of Divorce and Matrimonial Clause, define the idea of cruelty. The cruelty which is a ground of dissolution of marriage may be defined as willful and unjustifiable conduct of such a character as to cause danger to life, limb or health, bodily or mental, or as to give rise to a reasonable apprehension of such danger. Idea of cruelty in India further defined in Dastane versus Dastane by the Supreme Court in the year 1975. The Supreme Court decided that clear danger of life, limb or health or reasonable apprehension of it is a higher requirement than a reasonable apprehension that it is a harmful or injurious for one spouse to live with others. So friends, cruelty means bad treatment. actually bad treatment, or your conduct suggests that it is dangerous to live with you. It comes under the definition of cruelty, and cruelty is a ground of divorce under the Hindu Marriage Act. In a case of Sobharani versus Madhukar Reddy, it is defined that the action of man and woman are so diverse and indefinite that it is almost impossible to explain a general and exhaustive definition which would not fail in some case. The court enlarged the concept of cruelty and held that demand of dowry which is prohibited under the law amounts to cruelty. Friends, cruelty for the purpose of the act mean where one spouse has so treated the other and manifested such feeling towards her or him as to have inflicted bodily injury or to have caused reasonable apprehension of bodily injury, suffering, or to have injured health is a meaning of cruelty under the Hindu Marriage Act, friends. Friends, in the case of Savitri Pandey versus Premchandra Pandey, Supreme Court held that the cruelty has not been defined under the Act, but in relation to the matrimonial matters, it is contemplated as a conduct of such type which endangers the life of the petitioner with the respondent. Friends, by this discussion we are able to understand the idea of cruelty. Cruelty means actual suffering due to the external act of either party of marriage. Cruelty means a person actually treated you wrongly, or a kind of gesture and expression created by the either party of marriage which creates reasonable apprehension in the mind of either party. It also comes under the definition of the cruelty. Friends, now I want to focus on the cruelty under the criminal law. Section 498 AIPC, now section 86 of BNS 2023. The cruelty by husband or relative of husband is defined, friends. If as per the BNS section 86 Bharatiya Nagarik Suraksha Samhita defined cruelty under section 86, and as per section 86, if the husband or the relative of the husband of a woman subject to the woman towards cruelty, the husband or the relative would be punishable with the imprisonment for the term which might extend to 3 years and shall also be liable for fine. Friends, for the purpose of this section, cruelty means any willful conduct which is such a nature as it likely to drive a woman to commit suicide or to cause grave injury or danger to the life, limb or health, whether mental or physical, of a woman, is considered as the cruelty. Simultaneously, the BNS further defined that husband of the woman, subclass B, harassment of the woman, where such harassment is with a view of coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on amount of failure by her or any person related to her to meet such demand. Friends, the offence under this section is cognizable, non-bailable and non-compoundable. So this is the cruelty which is defined under the criminal law BNS section 86, friends. Now I want to focus on the different kind of cruelty. The cruelty may be categorized in two different kind. physical cruelty and mental cruelty, friends. Both kind of cruelty is objectionable under the law, problematic under the law, and sufficient for the dissolution of marriage, friends. Friends, in this context, I want to clarify you the meaning of physical cruelty. Friends, physical cruelty refers to any act or behavior by one spouse that causes bodily harm or poses a threat to life, limb or health of the other. It includes physical violence, assault and other harmful action that jeopardize the victim's physical well-being. Examples including beating, slapping and other form of physical abuse. Friends, physical cruelty is related with physical abuse, for example beating, etc. So when one party of marriage used force against another party of marriage, it considered as of physical cruelty, and physical cruelty is a cruelty, therefore it is a ground for the divorce. Friends, I want to illustrate the idea of physical cruelty with the help of the decided cases, friends. For example, repeated beating or beating after a long course of ill treatment is considered the physical cruelty. Mohinder Kumar versus Shraddha Rani case. The next is, friends, burning any limb of body is a example of physical cruelty. Karnal Singh versus Bhupender Kaur. The second is, friends, causing fracture of any organ. S.K. Garg versus Chanchal Kumari, 2005, Punjab and Haryana High Court. Administrating or feeding something that injurious to health is also considered as physical cruelty. Sayal versus Salra Rani. The next example is beating, neglect in providing food is also recognized as a physical cruelty. Babu Rao versus Susila Bai, AIR 1964, MP High Court, page number 73. Friends, keeping an illegal confinement, Gurudev Kaur versus Shravan Singh is also considered as physical cruelty. Stabbing is also considered as physical cruelty in a case of Vijay Singh versus Bhupender Kaur. So friends, these are the illustrative cases where the court identified the different kind of illustrations which are related with physical cruelty. If either party of marriage, beating, stabbing, keeping in illegal confinement, these comes under the example of the physical cruelty. Physical cruelty is a matrimonial offence. On that basis, divorce may be obtained by either party of marriage. So now I want to focus on the next category of the cruelty, that is the mental cruelty. Friends, mental cruelty means causing mental pain, agony, emotional stress, frustration, suffering or fear of such a magnitude that it serves the bond of love and liking between the husband and wife, as the result of which it become impossible for the party which has suffered it to live with other party. Friends, mental cruelty means any kind of mental stress, mental trauma, pain, frustration, fear originated from either party of marriage against another party of marriage. The mental cruelty also comes under the category of the cruelty, and therefore mental cruelty denotes a set of circumstances which through fall short of actual or physical violence. Means there is no actual and physical violence, but a kind of psychological pressure, kind of mental pressure provided by one party against another party. It comes under the category of mental cruelty and it is objectionable and a ground of divorce under the Hindu Marriage Act. Friends, now I want to focus on certain examples related with the mental cruelty. It includes wife doubting that husband was a illicit relationship with sister-in-law, continuously living in doubt and creating doubts. It considered as mental cruelty in a Nemai Kumar Ghosh versus Meeta Ghosh. The second example is, friends, a false charge against the wife that she was not a virgin and was suffering from the venereal disease. Suresh Sharma versus Sukhdev Sharma, 2006, Punjab and Haryana High Court. This is also considered as a mental cruelty, friends. Compelling the wife to adopt the life of prostitute is also recognized as a ground of the mental cruelty, friends. Marrying other women is also considered as a mental cruelty. Shyam Sundar Pandey versus Santamani Devi. Friends, wives join the Brahma Kumari sect and renounce all the interest in the matrimonial relation with the husband is also considered amount to the cruelty and considered as a ground for divorce. The next is, friends, a repeated threat to commit suicide. Prakash Kaur versus Harbhajan Das is also considered as mental cruelty. Marital infidelity of the wife and refusal by her to do household work is also considered as cruelty. Making the false and consistent charge of bigamy by the wife against the husband is considered mental cruelty. In Singara Singh versus Sukhvinder Kaur, causing injury to one's near and dear, for example, children's parents and brother, etc., also considered as cruelty. Refusal to take medical treatment and subject to medical test as advised by the doctor. It happened continuously, it also considered problematic. Making false complaints to the police resulting in the loss of reputation and prestige is also constitutes the mental cruelty. The removal of Mangal Sutra at the instance and instigating of the husband, retaining of the copies of letter written to the other spouse when the letter did not reply to any of them. So these are the examples of mental cruelty. Mental cruelty means absence of any kind of force. So there is a no force in a case of mental cruelty. Mental cruelty means a kind of stress is provided by one party to the another party. False charge on character, not treating the well with the children and parents, means generating and initiating the mental stress comes under the purview of mental cruelty, friends. So therefore, friends, I discussed two different kind of cruelty. One is mental cruelty, another is the physical cruelty. Both the cruelty is treated as matrimonial offense and it is the ground of the divorce. Friends, now I want to focus on the circumstances in which cruelty is not established. For example, courts not recognize that these are the sufficient cause to constitute a cruelty, friends. For example, mere filing an FIR by the wife against the husband is not sufficient for the cruelty, friends. Quarrels and heated discussion between the husband and wife not amount to cruelty. Asking to give loan to a relation is not amount to cruelty. Suggesting that the husband started his own business independent of his parent and take money from her parents for that purpose is also not considered as cruelty. Friends, when the court is going to consider something as a matrimonial offense, something must be exist substantially, not superficially. If something happened superficially, it cannot considered as cruelty, either mental, either physical, friends. Just an FIR, just a question, just a hard talk. If we thinking about that, no marriage can sustain in India, or you can say that in this holy world. Why, friends? Because peoples are behaving differently, family relations, the number of stress is also obvious in the marriage and family institutions. Therefore, cruelty, friends. This is the point which should be focused about that. The cruelty means something must be substantial. On that basis, the court may rely that it is sufficient to dissolve the marriage. Friends, now I want to focus on the point. Suppose a case of cruelty came before the court. So how the court will decide the cases related with the cruelty, and what should be the court's perception and presumption about the parties and about the conduct of the parties when the court is going to decide whether the cruelty exists or not, friends. So while determining whether a particular behavior amount to cruelty, the court must take into the account of the considerations. The first is not an ideal spouse. Friends, when you are approaching the courts as a husband and wife, the court is not going to rely on you, your ideal spouse. Because ideal persons may resolve their problem within the family, within the community, within the institutions. If you formally file a complaint against either party of marriage, therefore the court is bound to presume that they are not ideal spouse. Friends, in a case Dastane versus Dastane, Justice Chandrachud concluded that ideal couple or near ideal couple, one will probably have no occasion to go to a matrimonial court. Even if they may not be able to draw their differences, their ideal attitudes may help them overlook the glosses over the mutual faults and failure. Therefore, friends, when a person approaching to the court on the ground of cruelty, the court will consider that they are not ideal spouse, and therefore after verifying each and every fact, the court is going to decide anything, otherwise not. Now second point is, friend, not a reasonable person. The court also presume that they are not reasonable person, because therefore they are approaching on the basis of cruelty because they have a problem, friends. The concept of reasonable man as applicable in the law of tort is not applicable in the matrimonial home and the matrimonial law. The court have adopt a flexible yardstick from indivisible to indivisible, because what may be cruel to one person may not be cruel for another, friends. The court should not make any a priori assumption about the party. So as I want to clarify you that court is not going to make any kind of a priori conclusion, but court may think that they are not reasonable person, they are not resolving their dispute, therefore court will not going to take advantage to any party a priori. Court be careful, and by knowing and examining the facts will decide whether cruelty exists or not. Friends, now the court also focus on the personal and social aspects. Friends, personal and social aspects must be judged when you are going to discuss about the cruelty, friends, because without considering the background of the petitioner, you cannot decide the cases related with the cruelty in vacuum, because their status and environment, the norm and custom, tradition of marriage, tradition of married life, in their community, physical health and mind of victim should be considered before deciding the idea of cruelty, friends. Because we cannot decide the idea of cruelty in vacuum in ideal situation. We will focus on the community, we will focus on the family, we will focus on the parties, then decide that whether cruelty exists or not. The next point is, friends, inherent bias of conduct. Sometimes the court will rely on the conduct, what actually happened or committed by either party of marriage against any other party. Cruelty will be established if the conduct itself is proved, conduct itself bad enough and as per se unlawful or illegal, then it may constitute the cruelty. For example, friends, demand of dowry act per se is illegal, therefore in these cases the court may conclude that it is a case of mental cruelty, friends. False charge of illicit intimacy, etc. These are sufficient conduct to fall in the category of cruelty, friends. The next point is, friends, petitioner behaviors. Friends, the behavior of petitioners towards the respondent need to be taken into the account to determine the involvement of cruelty, friends. If his or her conduct is provocative, unsympathetic, aggressive, the respondent is not fully responsible for his or her hard response. Friend, the court is going to decide the cases related with the cruelty. The court also will focus on not number but nature of the act. The cruelty does not depend on the numbers of the painful assault but depends upon their nature and degree. Even a single act may be so grievous as to be sufficient to be branded as cruelty. So friends, the point is very clear. Number of event, number of cruel activity, conduct is not important. Nature is important. If conduct of either party is so grievous, then it comes under the category of cruelty, friends. The next point is, friends, no minimum period of suffering. So we also careful that there is no requirement that minimum period of suffering for the cruelty, friends. Friends, in the case of Lalita versus Om Prakash, fact, two sisters were married with two brothers. Within a week of a date of marriage, brother started complaining that a scooter was not given to them as a dowry. Elder sister was slapped by her husband and both sisters was not given food in the evening. The trial court observed that the period of 4 or 5 days was too short to come to the conclusion that respondent was guilty of cruelty. But the High Court held that no hard and fast rule that victim party must suffer for a certain minimum period before filing a complaint. So these are the considerations which are developed by the court when the court is going to decide the cases related with the cruelty, friends. Friends, a case Dayal Singh versus Meena Singh recently decided by the Allahabad High Court, where Allahabad High Court conceptualized the idea of cruelty, friends. And the observation of Allahabad High Court is very crucial in terms of cruelty, friends. Cruelty for the purpose of section 13(1) under bracket 1a is to be taken as a behavior by one spouse towards other which causes reasonable apprehension in the mind of latter that it is not safe for him or her to continue the matrimonial relationship with others. So due to the behavior of other party, one party think that it is not safe to live with others, share with others, share bedroom with others. The mental cruelty is a state of mind and feeling which one of the spouse due to the behavior and the behavioral pattern by the other. Unlike the case of physical cruelty, mental cruelty is difficult to establish by direct evidence. It is necessary a matter of inference to be drawn from the facts and circumstances of the case. Friends, a feeling of anguish, disappointment, frustration in one spouse caused by conduct of other can only be appreciated on assessing the fact and circumstances in which the two partners of matrimonial life have been living. The influence has to be drawn from attending facts and circumstances taken cumulatively. In a case of mental cruelty, it will not be a correct approach to take an instance of misbehavior in isolation and then pose the question whether such behavior is sufficient by itself to cause mental cruelty or not. Friends, the approach should be take the cumulative effect of the fact and circumstances emerging from the evidence on the record and then draw a fair inference whether the petitioner in the divorce petition has been subjected to mental cruelty due to the conduct of other or not. Friends, about this discussion, friends, we are able to think about certain points. To what extent is the court's observation that normal wear and tear in the marriage does not constitute cruelty, diluted when viewed through the lens of constitutional principles of equality and liberty. Friends, cruelty is a subjective idea. Could some guidelines be laid down to make it more of an objective understanding? Whether cruelty depends on the number of painful incidents or on the nature and severity of the conduct involved. Friends, on this discussion, we may conclude the discussion on cruelty. Cruelty is a very crucial grounds. Nowadays, every cases related with the divorce directly or indirectly associated with the cruelty, because it is very easy to argue on the basis of cruelty. A person is not treating me well, therefore divorce should be granted. Therefore, each and every aspects of cruelty is very crucial for the student and lawyers and general public also. Friends, cruelty means actual use of force. Physical cruelty or a conduct which creates apprehension in the mind of other party, and due to the apprehension, other party think that living with the partner is not fair. If I live with partners, it is injurious for my health, injurious for my mental and physical well-being. Friends, we discuss in detail about the physical cruelty and mental cruelty. Physical cruelty means actual use of force and violence against other party. Mental cruelty means a kind of conduct which creates psychological trauma to the other party and it creates psychological problem to the other party. It comes under the category of mental cruelty. The cruelty may be physical, may be mental. Any kind of cruelty is sufficient for the purpose of divorce. Friends, we also discuss the idea what the court considered when the court is deciding whether the case involved cruelty or not. Friends, in this context, we discuss that court will consider that they are not ideal spouse, because if they are ideal, why they are approaching the court? Why they not solve their problem? Now the second point is they are not reasonable men. The criteria of reasonable men cannot be like taught, but case to case the court will observe that whether they are reasonable or not, but generally law presume that they are not reasonable. Friends, I am not thinking and talking about the a priori conclusion by the court. The court is not going to draw any kind of a priori conclusion. but court think that they are not reasonable bad. But the important point is, friends, the number is not important, nature is important. The number of conduct which is objectionable, obviously actionable, but we will not wait a period. A wrongful act is sufficient to prove the cruelty, like burning any limb of the body, obviously comes under the definition of the cruelty, friends. Friends, we also discuss the different idea, and we also discuss a recent case decided by Honorable Allahabad High Court 2024, where Allahabad High Court concluded that both the cruelty are sufficient for proving the case of cruelty for the divorce, but idea of mental cruelty is more problematic because establishment of mental cruelty is not easy task, but by general evidence you are able to prove the idea of mental cruelty, friends. So therefore, friends, I am summarizing my entire discourse related with cruelty as a ground of divorce. This is a ground which is used fundamentally in a case of divorce. Therefore, it should be read very carefully. Thank you, friends. Thank you for your attentiveness.